Hennessy, come out and play.
This is it, Jennifer. Your big breaking Chii.
Yo, what's poppin', Henny? Gang. Bar is open, y'all. I smell a debunking video coming on. Child. Least we not forget, this is hennytea Reviews.
Having a fun time.
Yo, what's poppin', everybody? Welcome back to the bar. And in this video, we are going to take a step back into time, into the shady business dealings of old three-finger duty shooter CS2 Back, aka Wack 100. Now, for some of y'all, this is a refresher, and to some of y'all, this is new information. And the links to all of the videos that I'm going to play for y'all will be in the description box below. But in this first clip that I like to use as a little bit of an intro, I'm going to say shout out to SBGBTV for this soundbite, because we're going to get into all of the bad dealings that Wack 100 is attached to.
You just said that I'm associated with too many bad situations. Now, can you tell me what these situations are?
I sure enough can tell you what all of those situations are. And we're going to start off with Wack pulls a fast one on the church. 200, Kimberly Jones. Do y'all remember that name? Do y'all remember who Kimberly Jones is? That's Wack's, I guess, ex-wife now. Represented. At the time when I made that statement, there were talks of the two of them being divorced. But to this day, right now, as we speak, just like loose cannon, there is no divorce decree that is on record for Wack and Kim. So as far as we know, they are still married. Let's continue, y'all. To the plaintiff as their real estate agent in the transaction. In or about February 2019, Kimberly Jones informed the plaintiff that her husband, defendant Jones, which is Wack, okay, has offered to advance the church, because the defendant and the plaintiff, the church is the plaintiff and Wack is the defendant, okay? So Kimberly Jones informed the plaintiff that her husband, Wack 100, has offered to advance the church $250,000 needed to purchase and acquire the subject property, which is, the building and the land. Unknown to the church at the time, defendant Wack 100 and defendant Wilson were to split $250,000, with each of them paying $125,000. So now that means that Wack, unbeknownst to the people at the church, Wack made this side agreement with somebody and said, hey, we're going to lend this church $250,000 for them to get this, right? You're going to put up 125 and I'm going to put up 125. So at the time that this offer was made, it was unknown to the church that this is what was going on. It was a side deal that Wack had made unbeknownst to them again. Now, didn't we just recently hear about a side deal being done unbeknownst to someone else? Isn't this what we just heard when it came down to Adam22, that he was telling Mozzie over at Dosh Network, hey, you give him this part and I'll give him this part percentage out of mine, and then we'll give him this for him to screw him over later on, child, just like he did this church. But I'm going to let it unravel for y'all. Let's continue. I'm repeating that. They did not know that. As a part of the consideration for the loan to the church, Wack and Wilson were to take a temporary interest in the property through their respective corporations until the church repaid them the monies borrowed. So you got Mr. Wilson business, which is that holdings, and Wack's Fifth Amendment. going on to the deed or whatever it was that they did. We're going to get into it until they got the monies back. So you lending the money, but you holding the building hostage and the property. Until he pay you back. The church's obligations to repay was conditioned on obtaining a construction loan for the property, which the defendants which Wilson and Wack were to help the plaintiff obtain. Now, I'm quite sure I explained this a little bit in this video, but basically what's happening is they have backed this pastor into a corner to where he has to go through them to get this loan. And they are holding his property hostage until he gets said loan. Got it? Follow with me. The church was to pay Wilson and Wack back from the construction loan proceeds, which would trigger the defendant's obligations to transfer their interest in the property to the plaintiff. So that means that they would then transfer the property back to the church. In or about February 2019. Now, remember, this happened in February 2019 with that, right? All parties agreed to the above terms and the defendants and plaintiff entered into an oral agreement. So the church, Wack 100 and Mr. Wilson all entered into an agreement, an oral agreement. There was no paperwork. They shook hands. They did a gentleman's agreement. In or about March of 2019, escrow closed for the property with the following owners on the title as tenants in common: Episcopal New Life Ministry, BRH Holdings, and Fifth Amendment Entertainment. Now, because we have a lot of content to go through, I'm going to go ahead and speed this up just a little bit. And it's almost finished, but I want to speed this up just a little bit so we can get through it and get through all of the content. All right. All right. So now let's get back to it. So you got those three, okay, listed on the title as agreed upon. As required by the terms of the agreement, Mr. Wilson introduced the church to an affiliate, Griffin Capital, to assist the church in obtaining a construction loan for the property. Griffin Capital, in turn, identified a lender, Five Star Bank, to write the construction loan for the plaintiff. Doesn't this sound a little? This sounds so shady and shaky. This sounds like, y'all remember, Henny Glasses in the chat if y'all watched The Wire. Because if you watch The Wire, then do you remember when Stringer was calling himself going straight and he tried to get down there and play with them corporate dudes, and one dude was introducing him to another dude that was introducing him to another dude, and in the midst of all of that, he was shelling out all this money left and right, and they was bleeding them dry? That's what this gives me the feel of. Y'all agree? Because that's what it sounds like to me. So you gonna lend me, collectively, the two of you gentlemen over here are gonna lend me $250,000 for me to get the building and the land. Okay, y'all gonna lend me the money to get this. And then one of you is going to go and reach out to somebody who's going to reach out to somebody that knows you, that's going to approve my loan. The money from that loan, I got to give back to y'all $250,000 from the money that you've helped me to attain. Child. All right. Can we get a like check, please? Can we get a like check? Oh, can we get a... So in or about March 2019, escrow closed. Okay, we read that already. So they went into this oral agreement in February. In March, the escrow closed. On or about January 5th of 2020. So now we are in the next year. It's been almost a year. Okay. Five Star Banking sent the church an expression of interest letter outlining the general terms of the construction loan in the amount of the lesser of $1,250,000. So now he got a loan for $1,250,000. That don't sound, you don't find that suspicious? And out of that 1 million, you got to give 250 of that back to Wack and Wilson, which is supposed to leave you with $1 million. Okay, so as y'all heard, I made a mistake and I messed up. I meant out of the $1,250,000, they had to give Wack and Wilson $250,000 out of that 1 million, out of that loan that they received from this 5-star bank. And this 5-star bank, remember, is a bank that Wack and Wilson, they connected him to a person who connected him to these people, and these people approved him for that amount of money. Okay. Okay. And it says, or 65% of the appraised value of the property. All right. Y'all ready? Take the what and leave the what. Oh, but wait, there's more. There's always more. So this was on January 5th that he got approved for the loan from 5-Star Bank. And the name of the bank, you don't find that suspicious? 5-Star Bank? Isn't on or about January 14th, the church paid 5-Star Banking $5,000 as a good faith deposit towards obtaining the construction loan. Now, that's not unusual because sometimes they will ask you to pay a certain amount up front. Now, here's where the breach of the oral agreement comes into play, okay? The church incorporates and realleges, okay, we don't have to read that part. On or about January 20th, defendant Wack contacted the church and unilaterally attempted to amend the terms of the agreement by demanding that the church place his wife and his son on the executive board of the church, or he would cancel the construction loan with 5-Star Banking and not perform under the terms of the oral agreement. I'm going to highlight and read that again. On or about January 2020, which means after he was already approved and gave up his $5,000 to 5-Star Bank, he went to go amend the terms of the agreement, which was that he and Wilson go on the title with the plaintiff with the church, until he paid them back. Then once he paid them back, they would turn the whole title over to him. They then finagled and bamboozled their way into getting funding. So I'm going to slow this part down, bring it back just a little bit for y'all to hear. And we gonna slow cook that part right there, because that's where the breach of this oral agreement came into play. Okay. And the reason why I'm coming back here is because I'm showing you how Wack does not do anything that does not benefit him. There must be something on the back end that benefits him, or he has to be able to strong arm you. I said be able to. Lord ham and mercy. He needs to be able to strong arm you into doing what it is that he wants you to do. So now let's listen again. Terms of the agreement, which was that he and Wilson go on the title with the plaintiff with the church, until he paid them back. Then once he paid them back, they would turn the whole title over to him. They then finagled and bamboozled their way into getting funding. Once the funding, after he done paid this money out, he gonna say to him, put my son and my wife on your board, your executive board of directors, or else we not giving you this loan. I was shocked and appalled. I told you, didn't I tell y'all this was gonna be some good henny? It's good, okay? The plaintiff refused Wack's demand. Consequently, the construction loan with 5-Star Banking failed to process any further despite previously being approved. Now, let me ask y'all this, because I ain't never heard of this before. How can he stop somebody's loan when he don't have nothing to do with it? I'm going to pause that for a minute to break this down as to what happened for people who may not understand what have happened. So what has happened is Kim brought Wack into the fold with this church, right? Wack is going to lend the church monies so that they will lend the pastor money so that he could purchase this church, this building, and the land. Wack says, okay, I'm going to do that, and brings in his partner, Wilson, cuts a side deal with Wilson and says, I'm going to give him half the money. You give him the other half of the money. When he gets approved for this loan, which basically I'm going to work a little flimmery. Okay. You're going to find out about how he works his flimmery. Okay. I'm going to work my flim, and we're going to make sure that he gets approved for this loan. And when he gets approved for this loan, what he's going to get is $1,250,000. So that way we are guaranteed to get back our $250,000 in that loan. The loan comes through. The loan people, Five Star Bank tells the pastor, give me $5,000 up front as a show of good faith before we release these funds to you. Now here comes Wack. Put my son and my wife on your board of directors, or else you're not going to get this funding. If he doesn't get the funding, then that means that he does not get the building. He does not get the building from Wack and Mr. Wilson. So he dangling what the man want to give him what he want. You see how he set people up? He shows up like a friend when you are in need, and he sets you up for the downfall, or he puts you in a position to where you are always in his pocket. Now, if you want to watch that whole video, you can go ahead and do so. It'll be the second link, because the first link is going to be to SB, the video in the beginning by SBGB TV. That'll be the first link. This full video will be the second link, okay? Now, what we're going to get into next is we're going to get into a little bit of this next video, okay? Wack's questionable practices when it comes down to how he was handling the games lawsuit when that came about. Y'all want the hennytea. Okay, so now let's pull these docs. Let's pull these docs, because how is it that she gets awarded this funding, yet she don't see a dime? Well, baby, enter in Wack 100. This is where the shady dealings of Wack 100 comes into play, because let me see if y'all can see that good. Let me see if y'all can see that good. Let me do a check. Explain to you what is going on here. Okay, what is going on here is the game is signed to Wack 100. We all know that he was signed to Wack 100. This lady had a lawsuit, and of course Wack 100 inserted himself into said lawsuit under the guise of being the game's manager. What were the shady practices that he did is what we're going to get into. So please understand that while I am speaking on the game's case, please understand the game is not the focal point of this video. The shady dealings of Wack 100 is the premise of this video. But as I explained to everybody, somebody is going to catch a stray. And today, the stray goes to the game. All right, y'all. So I'm going to get into this. Y'all know that this is the Priscilla Rainey case, and this is where she is coming at them for alter ego liabilities, voidable transactions. Anyway, so as you can see, Priscilla Rainey, which is the young lady that we saw in the video, Priscilla is suing Jay Sion, aka The Game. She is suing JTT Holdings LLC, F12 and Associates LLC, Fifth Amendment Entertainment Inc., Pass Go to Win LLC, and Cash M. Jones. And yet he keeps saying that his name is not on lawsuits, but they are. These are the charges against him. Well, against them. Alter ego liability, voidable transactions pursuant to California Civil Procedure Section, conspiracy to commit voidable transactions. Okay? Conspiracy to commit voidable transactions. Now, Cash Jones is Wack, you guys. For those of you who do not know, Cash Jones is Wack, okay? So Jones and Taylor is Wack and The Game. Now, this case started in 2015, okay? Just a little refresher. This case started in 2015. This right here, this case, this right here was in court 9/13 of 2021. And we are in 2024. I do have an update in 2023 that I will pull for you guys. But basically, okay, so it goes into the parties. This is the judgment that she got on November 18, 2016. The U.S. District Court in the Northern District of Illinois entered a judgment against Taylor in favor of Rainey for $7,130,000, $7,130,000 and $100. Okay, so the girl basically, you know, got 7.1 million and some change, a little change on it. Okay. Before the judgment was entered, Taylor has fought tooth and nail to avoid being held accountable for his actions. Indeed, Taylor, which is the game, has consistently employed myriad evasive tactics before, during, and after trial. Okay. Most of which were meticulously documented in the U.S. Court of Appeals. Okay. On the date of this complaint, Rady has collected. So as of the date of this complaint, she collected $258,058.33 from his royalties. So if you don't know, what had happened was she was awarded his rights and royalties. Like all his royalties that were, supposed to go to him, they go to her. Okay. Which represent approximately 3.62% of the principal of the judgment. Okay. But most of the judgment remains unsatisfied as $6,872 and $6,872,041.67 is still outstanding as of the date of this. Okay. This right here document goes into all of the charges that were brought up against him. May 25th of 2016, Rainey's trial counselor took the deposition of Jones, which is Wack 100, in the underlying action. Jones is Taylor's manager. According to Jones' testimony in his 2016 deposition, Jones was Taylor's sole manager since approximately 2014. Now I'm gonna circle back to this. So put a pin in that. Remember, 2014. You definitely want to put a pin in that, because baby, we're gonna also listen to them transcripts that I put out as well, because in them transcripts you gonna hear him say something completely different about his management relationship with the game. So put a pin in that and remember what you just heard. Taylor's management team and was on Taylor's management team for 6 years prior to being his sole manager. So prior to becoming his sole manager, he's saying I was on his team 6 years before that, baby. He said when asked at the deposition what he did in his capacity as Taylor's manager, Jones responded as follows: everything from his day-to-day to his mortgages, to his record deals, to his flights, to his ground support. I mean, whatever. I book his shows, maintain his publishing contracts. I mean, you name it, A to Z. Jones has a record label by the name of Fifth Amendment Entertainment Inc. Now, for those people who get down in the comment section and be quick to fight and windmill and kung fu and all of that, who keep saying when I say to them, what happened with Blueface was a tragedy, and that Wack, being his alleged manager, was supposed to do more for him, and they keep saying now he's not the he don't handle that. He's his manager. That doesn't mean that he handles his personal stuff. Did you not just hear what he just said in a deposition? He said he handles everything from the day-to-day to the mortgages to everything. He manages. So if he's doing this for the game, why he wasn't doing that for Blue, and Blue end up in the situation that he's in? Don't worry, this is just part one. We're going to get into a part two as well. I did not forget. Okay. Although Jones incorporated a company by the name of Fifth Amendment Entertainment Inc. in California in 2007, the last statement of information was filed in 2010. As a result, that company has currently been suspended. Did y'all hear that? Fifth Amendment was currently suspended at that time. It was suspended. Child, Henny glasses in the chat if y'all want me to pull on Wack businesses, because I sure enough will pull it on up. Okay. Subsequently, on or about August 25th, 2015, Jones incorporated a similarly named company, Fifth Element Entertainment Inc. in Florida. Y'all remember this right here, okay? In his deposition in 2016, Jones testified under oath regarding the following for Fifth Amendment. I'm paraphrasing now. So what happens when I do business is what happens when I do business, it is going to be between Fifth Element and that company. And then I establish a contract between Fifth Amendment and the artist. Game as an independent artist. So how is it that let me shut up. Anyway, he is not tied in or assisted or assigned to nobody. So what I was about to say that I didn't say is if he's an independent artist, how is he signed to Fifth Amendment and you are his manager and manage everything from his day-to-day to booking his shows and all of that? How are you his manager if he is independent? Make it make sense. Somebody explain it. Even E1 Music, E1 has a joint venture with my company, a contract game for the projects. Once the project gets rolling, then I fall into my management position. But listen, let's get one thing straight. This is what Wack said. Now listen, this sounds real fishy to me. I'm right here. Let me pull it up. I'm right here. But listen, let's get one thing straight. You will never find a contract between nobody and Jason Taylor direct. How is that possible? So is he not under contract? I'm confused. Or do you mean peoples? You will never find the peoples. So now in this document, as we go on to read this, JTT Holdings LLC. Let's start there. JTT Holdings LLC. And if you know some of this, please let me get the story out. JTT Holdings is the games company. It's his LLC. He's the sole owner, sole operator. He's the only one that deals with JTT Holdings, okay? It says on here, moreover, two of Jones' companies, Fifth Amendment and Precise Auto Transportations, Inc., entered into several contracts with Entertainment One, which is E1. Now, E1 is in charge of the game's royalties. So explain to me this. This is where the shady shit start coming in, y'all. How is it that Precise Auto Transportation, now we know Fifth Amendment has to deal with the music, right? Precise Auto Transportation, Inc. entered into several contracts with Entertainment One for services of Jason Taylor, which is the game, collectively. E1 is an entertainment company, which among other services distributes music and provides royalties to the artists. So now there's already one interception happening right there between his two companies. Okay. According to post-judgment discovery obtained by Rainey on June 11, 2016 and November 3rd, 2017, E1 paid approximately $905,000 to Jones through Fifth Amendment via a VS check and or wire transfer that was specifically referenced the game. These monies paid by E1 to Jones were not for services that were performed by Jones, but rather were monies that were owed for Taylor services. Jones and Taylor conspired to hide the judgment collection efforts and have hundreds of thousands of dollars that would otherwise belong to Taylor be paid to Jones. Do y'all see what's happening here? Henny glasses in the chat if y'all see what's happening here. Now, I know a couple of y'all was already in the comments talking about, oh, he has shell companies and doing this, that, and the third. But do y'all know the story? I'm giving you the story, sweethearts. Okay? Now, okay, so we don't read that. So now let's get into the JTT Holdings LLC because all of this ties in together. Let's get them likes up to 250, y'all, because we had 235 and we got 264 viewers. So let's get them likes up, please, and thank you. Let me do something real quick. I just want to check on my audio because sometimes my audio be sounding a little to me. Just to me. It probably don't sound like that to y'all, but it sounds a little to me. What is going on here? Okay. What is going on here is the game. Decide. Okay. It does sound a little to me, but it's all right. It's not bad. Rico needs to tap on Wack's shoulders. Listen, baby, we at 243, 246. Gold Digger says we at 246. Can we get 4 more likes in the chat? Absolutely. They are big. Now, see, this is the thing. Like, y'all know I'm good for leaving my mic muted. Anywho, what I was saying was I did this video back in April, April 24, I believe is what it said, but it says 9 months ago. Now, it did give me the date. Y'all saw the date. That was in April of 2024 that I did this. And a few short months later, we would stumble upon the Rico with him and Jared Milgrom and Ray J. How could we ever forget that, right? Right. Shout out to the Henny legal team for pulling on them docs. Yeah. Okay, shout out to y'all. But anyway, this right here, I'm gonna continue for a little bit longer, but y'all make sure y'all are getting those likes up in this comment section of this video, okay? Make sure you're getting the likes up because I'm taking y'all down memory lane, and this is just video 1. There's going to be another one because I'm going to show you, I'm going to expose him in paperwork of how he does people dirty. Because see, here's my thing. I am focused on what is happening with Adam22, okay? And Adam22 needs to see this video. He needs to go watch those other videos. He needs to look at everything that has happened to all the people that end up partnering up with him. And he needs to run, Forrest, run far, far away from Wack 100. Like I said, I know some of y'all was already talking about, oh, he hiding the money. But I'm about to tell you how they hiding this money and how much they hiding the money. Because there's rumblings about this. But nobody ever got into the details of all of this. And I'm finna to get into all of the details with all of this. Up, we need one more. Gold Digger has said that there's 249 likes. Can we get one more? Is there one more in the house tonight? Can we get one more like so I can continue? Okay, we seeing 250 gold. Can you confirm it's at 250 or you confirm? Because I'm seeing 251 too. Let's go, y'all. Trying to see where we at, baby, because you know I got to stop every now and again. My apologies, I got to stop every now and again. I should have skipped past this, but my bad. I'm serious about my life. Thank you for the Cashapp, Evelyn. I appreciate that. Okay, we had 252. Go and score. So let's continue and carry on with all of this, and let's find out exactly what happened. Okay, so Taylor also received direct income from Jones through Fifth Amendment through Taylor's wholly owned Nevada limited liability company, defending JTT Holdings, LLC. On or about November 16, 2014, Taylor opened at least 2 accounts at Wells Fargo under the name JTT Holdings, LLC. The account opening application states that Taylor, the game, is the sole owner of JTT Holdings and that the description of JTT Holdings business is name branding. Okay. Account statements for JTT Holdings account at Wells Fargo reveal that Taylor uses JTT Holdings account to pay for personal expenses. So he's funneling his money, the game is funneling his money through this Holdings LLC company to pay off his personal bills. That means to pay his light bill, to pay his car notes, to pay for his food, to pay for his clothes. This is where that money is going instead of into his personal account, okay? To everybody who was just joining, what's popping. If you are new here, please be sure to like, comment, and subscribe and click that notification bell. Select all so that you know when I do a video, okay? Now let's get back into it. All right, from January 19th, from January 2019 to December 2019, that's for a whole year, the whole year of 2019, Jones, through Fifth Amendment, transferred $649.80 to JTT Holdings at the Wells Fargo account. I'm going to read that again. For the whole year of 2019, Jones, Wack, through his company, Fifth Amendment, transferred $342,649.80 to JTT Holdings, the game, through his Wells Fargo account. Baby. Now, allegedly, allegedly, let's throw that up in there just for spice. Allegedly, okay? Allegedly. All right. The legal okay, so now we get into the property. We get into the property now, right? Now, y'all listen, because there's some shady going on with the property too, baby. Okay, let's get into it. While Rainey's enforcement efforts were ongoing, the game, JTT Holdings, and Wack conspired to deprive Rainey of collection monies by fraudulently transferring Taylor's interest in JTT Holdings to Jones. And the property located at, and I'm sorry, I did not block that out, Mulholland Highway in Calabasas. Now, wait a minute. Hold on, y'all. Henny Glasses in the chat. If y'all remember that Adam22 video that he did, where they was talking about being in Calabasas, and Wack said, I own a home in Calabasas. Now, for y'all content bandits, don't y'all go out there stealing that video from me before I can find it, okay? Because I know where it is. It's somewhere in my history, but don't y'all go stealing that, all right? Let me have a little glory, just a little bit. I'm just asking for a little glory, okay? Yes, baby. Well, this home, the game's home, was in Calabasas, California, okay? So, they transferred the property from JTT Holdings to Jones. Both of these transfers are avoidable as described below because they were made in actual attempt with an actual intent to hinder, delay, or defraud Taylor's collectors, including Rainey. Now, Wack has gone on to brag about how he has been able to hide money from this girl, Rainey, for years, and how the game has not paid a dime, but he has, and that'll be in part 2 of this. But now we're going to move right on along to what happened when he went to court for Keefe D. Okay, we're going to read how the courts called Wack out and what they think about him and how they feel about him. The rest of that video will be down in the description box. And trust me, we'll be back in that video soon. But now let's hear what was going on over here in the Keefe D case when he showed up over there. I got it. Give me a second. Because we're going to... Now, let me come back to over here because... Let me cover my screen. Let's put up Rumor Has It, shall we? And let's play this video. Y'all ready?
That's good, nigga. I'm finna bail out KBD. Nigga, that's good work. What you mean? On my mama. I don't give a fuck about all that. Nigga, you talking about KBD Raddick, that bitch ass nigga? What's that nigga from New York? Raddick, because they was fucking his bitch.
He's talking about 6ix9ine, and he knows good and full well who 6ix9ine is because we know that he has dealt with 6ix9ine. But Wack got jammed 6ix9ine, Wack got 6ix9ine jammed up too. Again, don't worry, this is only the first video because there will be more. Okay, I keep saying that because I want y'all to be on the lookout for it because it's going to be more than one. All right, and this is recent because that was a recording that took place not too long before this audio came out on July 9th of 2024. This is what Wack was saying. Okay, and if you remember that whole little thing about him and 6ix9ine working together and all of that, that happened way before the Keefe D trial. This audio came out during the Keefe D trial, and it spoke to what his ill intent was for Keefe D. Remember what I said. He shows up as a friend when you are in need, but Wack don't help nobody unless it's going to benefit him. Let's get to it. That's Tekashi 6ix9ine. That's crazy.
About that, TPD has a book already out, and he's going to be going to trial, and the world's going to be watching. And Wack's going to already have the first 10 episodes shot. What are you talking about? Give a fuck about no rat. What the rat got to do with the bag?
See what I'm saying? He was helping Keefe D. He was willing to help Keefe D to get out because he was after Keefe D's life rights. He was trying to film the Keefe D story. So as long as he was going to benefit off of that, he was willing to help him. Let's continue.
What rat got to do with the bag, bro?
And he has also said that he has no problems with working with a rat. Come on, bro. Come on, bro.
Nicky Barnes is another rat. Y'all just say what.
Okay. So did y'all hear that for yourselves? The world is going to be watching. That's where I got it from. Oops. The world is going to be watching. And I'm going to have the first 10 episodes. Child, you know what he's like? He's like somebody grandma. No offense to anybody grandma now. Now, y'all know what I'm about to say, because y'all know what I'm about to say. He's like one of them old ladies that sit in the window and run their mouth all day and just don't know when to shut up. But did y'all hear him say he will work with a rat for a bag? He'll work with a rat for a bag. I'm just saying. I'm allegedly. Allegedly. Just saying. All right. So now you heard the recording. All right. I think that's the recording. I'm not 100% if that's the recording because I don't have the disc, but that's a recording of Clubhouse where he running his mouth. Jones stated that as a result of Davis signing the contract, Jones is going to provide the funds for the defendant's bond. Jones makes explicit that he is organizing the television portion of the deal. Jones' audio mirrors his jail conversation, stating that he wanted to get 10 episodes before the trial. So again, maybe that's not the recording they heard, but that's the recording we heard that said the same damn thing. You just a girly mouth. You a girly. I don't even want to call you a girly mouth because we don't even run our mouths that much. It's a special kind of person that be running their mouth, and you one of them. You that type of person. I don't even want to classify him with my gender. You're not a female, you're not a girl. I don't know what you are. But don't sit him over here with us, please. Don't call him a girl. Don't call him feminine or none of that because he's not like us. Some of us are more solid than some people's right-hand mans. I'm just saying. He ain't like us. He a special kind. Okay. Okay, mirrored his jail call conversation with the defendant, stating that he wanted to get 10 episodes done before the trial. Jones further stated that he met defendant one time in his life. So pause, you met him one time in your life, but that's your good friend? Or that's your good girlfriend? I couldn't help myself. I'm sorry. Anyway, Jones reiterated that he put up the money as quid pro quo for defendant's life rights. He wants Keefe D's life rights. It's right there in black and white. Quid pro quo, for people who don't know what that is, even though I think we've gone over this before, is I'll do this for you if you do this for me. But of course, these public statements did not prevent Jones from attempting to perpetuate a fraud in this court. On redirect examination, Jones represented that the contract being discussed on the jail call between Jones and the defendant was about a car title. Pause, remember? He said, because you got a car on the East Coast. and they got to get it back over here. A very well-known car on the East Coast, and he got to bring it back home. So that's what the contract was for. But we knew that was a lie. Source hearing, blah, blah, blah. This is yet another false statement by Jones made under oath. Later, when asked by defendant's counsel if defendant has anything in writing that says that Jones will receive a benefit from defendant's story and release, Jones responded with an unambiguous no. Even this court attempted to cut through the morass of false statements by Jones. I'm going to start using that. Isn't that just so poetic? It's like you got to say that with your pinky out. So let's do it together, everybody. Put your pinky out and say morass of false statements. Oh, don't that feel so bougie? Make you feel bougie on the inside. Why are you over there telling me those morass of false statements? All of that morass of false. Yes, honey, we're going to use that in some sentences going forward. I like that. That's a classy way of saying you a bold-faced lie. In a court of law, they calling you a liar. They on our side. They see like us. I'm sorry, y'all. Let me get back to it. Asking Jones to explain the contract discussed in a jail call between Jones and the defendant. Rather than answer the court's questions, Jones rambled nonsensically. Meaning he just ran his mouth. Oh, I like that. Rambled nonsensically. Why are you over there rambling nonsensically? Now y'all see where I got the morass of false statements and rambling nonsensically from. It came right up out of these court docs, y'all. This is what they called him in court. Oh, that's so bougie. Y'all hear this? We about to start. I gotta write some of these down because I'm gonna start putting that in my vocabulary. Okay, it sounds bougie. At the conclusion of arguments by counsel, this court stated that it was left with more questions than answers. But after Jones' testimony, one answer is clear: that Jones cannot be trusted to tell the truth. Jones has forever damaged his credibility and given the deception. Any representation made by Jones should be wholly disregarded. Yo, the courts have deemed you a liar. You can't be trusted. They don't want to hear nothing you got to say. You're not a credible witness no more. You can't ever take the stand again. The court said that you're a liar. Morass of false statements you gave them, and you rambled nonsensically. Oh, don't that sound like you just really, Okay, so now let's go down here. Let me take y'all down. Where is it? Because I'm trying to find the letter. Explained to Clemens that the money came from another benefactors, including the bank records, and Jones implied that Jones is not the source of the funds used to procure defendant's bail bond. Davis explained to me that it's in the court doc, and I'm just reading it, so I don't mean no offense or no harm to nobody. While defendant later claimed that he was lying to appease his wife, defendant had similar conversations throughout his time in custody. A small sampling includes February 2nd of 2024. Davis indicates he has a Jewish partner that is willing to put up the funds, but does not want to be on television. February 2nd, 2024 jail call. Okay. But they're giving me too many commercials, so I ain't even gonna bother with that. What I will do for y'all, and I promise I will do, is I will make a video with that portion in the video. I will clip this up myself and make a video with that in there. So we ain't gonna even be worried about all these damn commercials when I'm moving the needle around. We just gonna keep going. Defendant's conversation. All these damn commercials when I'm moving the needle around. We just gonna keep going. Defendant's conversation. That portion in the video. I will clip this up myself and make a video with that in there. So we ain't gonna even be worried about all these damn commercials when I'm moving the needle around. We just gonna keep going. My bad. We don't have the video. So like I said, we gonna just keep going. Defendant's conversation with Paula Clemens confirms what the bank records and Jones implied, that Jones is not the source of the funds used to procure defendant's bail bond. Davis explained to Clemens that the money came from another benefactors, including the Jewish guy. Now, I didn't say that. It's in the court doc, and I'm just reading it, so I don't mean no offense or no harm to nobody. Do you notice a pattern of behavior here? Do you notice how there is always a third party involved in everything that he does? And in this situation, they're speaking of another gentleman that is involved. While defendant later claimed that he was lying to appease his wife, defendant had similar conversations throughout his time in custody. A small sampling includes February 2nd of 2024. Davis indicates he has a Jewish partner that is willing to put up the funds, but does not want to be on television. February 2nd, 2024 jail call. Okay. May 17th, 2024. I'm sorry. Defendant's son stated that he was doing a deal with Paragon and Cuz through Crater Face. Cash Jones. I didn't make that up. Y'all see it right there on the paper. It's in a court doc. They done called him Crater Face in the court doc. And the deal is done. The son is sending him, Jones, the PDF, and the defendant will be out of there. The defendant's son further relayed that the person who was fronting the money said Davis can smoke all the ganja he wants, and all he must do is sit at home. The son wants to connect with the person from Paragon with defendant's attorney. The son also told Davis that Youssef must be involved in the deal per the guy from Paragon. So this is all on a jail call. Y'all talking on jail phones? How grown are you? You don't know not to run your mouth on them phone calls? It tells you when you get on the phone that this call is being recorded for monitoring. This call is being recorded for monitoring and whatever. I can't remember verbatim, but I do know that that's what they tell you. All right. For monitoring and quality service or something like that. I don't even know. Okay, May 22nd, 2024, the person on the call tells the defendant that the Jewish people have the money to get him out. On May 31st, 2024, the person on the phone tells the defendant that the production company associated with Mary cannot be associated with bonding Davis out. The world's dumbest criminals, boy. So the company needs to set up an account to pull the bond money from there. June 23rd, 2024, the person on the call asked the defendant who's pulling up the money for the bail. Wack who? And defendant responds, yet another name. These calls a mere sample of the scheming defendant has engaged in to obfuscate. Listen, I don't know how to say that word. All right. Obfuscate, I believe. If you look it up. The source of any funds received further validate defendant's admission that Jones was merely a front or middleman and not the original source of the funds. Bank records themselves that defendant cannot assure this court as to the origin of the funds used to pay the defendant's bail bond. As such, this court's findings that the defendant did not make a prima facie case that the source of the funds was legitimate is correct and should not be disturbed. So you ain't proved your case. Not only did he not prove his case, he still did not prove where the origin of the funds came from. But the one thing that everybody from the courts to the streets can all agree on is that it did not come out of Cash McElroy Jones' bank account. Now, as to the authority that they were talking of when they were saying the courts don't have a right, the court has the authority to set conditions on the source of money used to fund defendant's release from the detention order. Defendant claims that this court can only examine whether the source of the funds come from a illegal substance source and cannot put forth restrictions on the source of the funds. Defendant's understanding is incorrect. This court can impose any conditions for release as long as the conditions is the least restrictive means to protect the safety of the community or to ensure that the defendant will appear. This court determined that the defendant was a danger to the community after lengthy arguments and reviews of the factors listed in NRS 178.4853. As a result, the court determined that the decision order was necessary to protect the community to set the bail at $750,000. Now, what I'm getting from this is they figured we're going to set the bail that high because we know through his assets, he ain't got it. So we're going to set it that high because we don't think he's going to get it. But my thing is, I feel like y'all should have never gave him a bail in the first place. Like, since when do you unalive somebody and get a bail? I mean, it could happen. Courts can do what they want, but I'm just saying, why would you in such a high profile case where somebody was who allegedly did all of this? And I have to say allegedly. It's a high profile case. They got up here and they just bragged about it everywhere. Why would you give them? Let me shut up. That's another video for another time. Anyway, this court further ordered that a necessary condition of release was that the source of funds could not be from illegitimate sources, including proceeds from defendant profiting from his involvement in the unaliving of Tupac Shakur. This court's concern was that releasing defendant with funds used to celebrate his criminal acts, included admitting to unaliving, would not keep the community safe and would run afoul of the purpose of the court's detention order. This condition, based on factual findings within the court's inherent authority and complies with the order, as well as Valdez Jimenez, I think I said that right. Moreover, even a gift of funds to the defendant would contradict the purpose of the detention order issued in this case. The logic of the setting of the detention order of $750,000 is to create a sizable financial consequence to the defendant if he were to be released and continue to engage in conduct that endangers the community. So pause, aside from what I said, there you have it right there. You got all this money up on the line. So you're going to follow the rules or you're going to lose this money. Okay, and whoever's putting this money up ain't going to be having it. Okay, allowing the defendant to use money that is a gift is the functional equivalent of giving defendant his own recognized release. He has no fiscal incentive to obey the terms of his release, to stay out of trouble, or to show up to court, thus defeating the very purpose of the court's decisions. So no, you can't give that to him. We want him to come up with that money because if he takes this money and puts it on the line, he's more likely to follow the rules and regulations. But you gifting his money means that he's not going to follow the rules and regulations because it ain't his money, it ain't his property, it holds nothing of consequence to him. So he can do whatever he wants, and you'll be the one left holding the bag. I totally get what they're saying. When granting bail, this court reviewed thorough briefing and relied on information available at the time, heard extensive arguments, and made plain the conditions of release. Defendant did not ask this court to reconsider those conditions in the time immediately following the court's ruling. Instead, defendant waited until he was caught attempting to deceive the court to change the court's findings. But mere inconvenience to defendant should not disturb this court's findings that a detention order is necessary to protect the public. This court's order that defendant should not be able to use profits from unaliving Shakur to secure his release is permissible. Okay, where we at? Now we at Cash Jones irreparably damaged his credibility as a legitimate source of funds. His credibility is damaged. It's damaged with the court. Did y'all see that? Let me bring this down a little bit. Cash Jones irreparably damaged his credibility as a legitimate source of funds in a court of law. So you being a source of funding for people is now damaged. It's getting good. Whether or not defendant Jones agreed with this court's stated conditions that defendant cannot use monies granted from his unaliving of Shakur to fund his bail, Jones is still required to testify truthfully while under oath. Call me a liar without calling me a liar. And in this regard, Jones' testimony was an abject failure. They definitely called him a liar in a court of law without calling him a liar. Even the courts know it. Sorry. The source of the hearing. At the source hearing, defendant called Jones to testify as to the circumstances surrounding the gift, the bond, to defendant. Notably, it was defendant's attorney who asked whether there were any strings attached to this gift. Specifically, defense counsel ended his direct examination of Jones by asking if he was deriving any benefits financially from Mr. Davis's release. Jones responded unequivocally, "No, I'm not." But this story of the bond merely being a gift quickly unraveled. When asked by the state if there was a contract between defendant and Jones, Jones responded, not as of yet. When asked if there was a financial agreement with the defendant, Jones responded, not as of yet. This is hardly consistent with the bond just being a gift, as attested to by Jones's letter. When asked if there were any stipulations associated with the defendant's release, particularly as it's related to television series, defendant denied it and claimed that he had nothing to do with television. And we just heard that there was something to do with television that was going on, and the courts heard it as well because they were listening in on Clubhouse. Now, I'm going to tell y'all one more again, because I've been telling y'all since them RICO cases, all of y'all out there in Clubhouse land, y'all going to find yourselves on an indictment. Y'all keep messing around with Cash McElroy Jones. I'm telling you. I just showed y'all. Let me remind y'all. He had nothing to do with television. Remember that. That's what he said, right? Nothing to do with television, but he did have. Now, this right here is an older document from 2015, and I'm going to break that down for y'all. At one point in time, and he's an executive producer on a show right now. That's a source hearing. Of course, this court heard Jones say the exact opposite of his sworn testimony to DJ Vlad. There, Jones stated that he was going to bail out defendant, but only with the stipulation that Jones does a TV series with the defendant, okay? Later, defendant was asked if he discussed a contract with the defendant while defendant was incarcerated. Jones answered that he merely inquired if defendant signed his life rights contract with someone else, and if so, why hasn't that person come to assist Jones? Hearing transcript, page number 10, all right? Again, this was contradicted by defendant's own words after Jones sworn testimony that there wasn't a contract and that Jones had nothing to do with the television series. So again, this is to show you that Wack does nothing, and I'm going to keep drilling that in, without it being beneficial for him. And let's remember, he is lying under oath, and they are calling him out on him lying under oath. Now we're going to skip over to this portion of the video. I am going to do a collaboration of all his business entities and all of his fraudulent stuff, because we've gone over this stuff, but I'm going to remind y'all that he is a fraudulent businessman as well. Okay. I'm going to show y'all about how he tried to flim-flam the courts with paperwork. Child, pay attention, because he's a slippery sucker, ain't he? The last annual report they received was December 31st, 2020. This is Nevada Business Portal, Silver Fumes. Look it up for yourself. The entity status is revoked. He don't have a business in it. So he's going to bring them some articles of incorporation for a revoked business. Child. Now, I explained earlier in this portion of the video about LLCs. And basically what I was explaining was, once you file for an LLC, it is up to you to keep up with your paperwork and stuff. He would have gotten articles of incorporation are not hard to get. However, that business is revoked. So he is moving. He is not even a smooth criminal. He gave the courts bank records to this business right here. And I'm going to tell you something. All you really need to open a business account is the EIN number for that business. But as far as him being registered, the last time he filed his annual reports with them was back in 2020. And that business is revoked. And you can see it for yourselves. It's right here on the paperwork. It says entity status revoked. He never turned in any more annual reports because you have to report annually. And he did not. Well, let's continue. You can't make this up. Okay, 2, Nevada Secretary of State, Domestic Limited Liability Company. Okay, he's going to bring that. The Internal Revenue Services Employment Identification Number. Notice how he's bringing all of this up. The bank, hold on, pay attention, stay with me. Okay, the Bank of America banking records for 100 Entertainment. Now, pause. This ain't the same company. Look at the spelling of that company. That is 100 Entertainment. Okay, but he says 100 spelled out Entertainment LLC. Two different businesses. Two different businesses. Okay, he's going to bring the banking statements from 100 Entertainment dating from December of 2023 through June of 2024. Checks for $35,000 from 100 Entertainment to Smiley Face bail bonds. Smiley Face bail bonds received to Cash Jones in the amount of $112,500. Pause. That's not what they're looking for. But anyway, let's continue to see what else he's supposed to be bringing. Specifically, the court alluded to being confused to where the monies came from since the court was provided the 100 Entertainment banking records only up to the month of May of 2024. The records of June 2024 were not immediately available at the time of the hearing, but have now been provided to the court. On June 11th of 2024, a deposit received from AG Entertainment Touring, a customer of 100 Entertainment, in the amount of $112,500 for the payment of services received. How ironic that you received that payment in that amount. The amount that you needed just happened to be dropped in your lap. The total amount in the 100 Entertainment bank account was $203,231.93 for the month of June. More than sufficient to cover the bond premium of the 100. The bond premium. I ain't gonna keep saying that number. On the same date of June 11th, Mr. Jones authorized the payment of $77,500 to Smiley Face bail bonds for partial payment of the bond premium. On June 12th, Mr. Jones issued a check in the amount of $35,000 to Smiley Face bail bonds, which is being held by the bail bond company and will be deposited only when the bond is approved by the court. As of June 28th, 2024, the balance in the 100 Entertainment bank account is $75,600.67, which is sufficient to cover the check issued by Mr. Jones. Okay. Based upon the foregoing, Mr. Davis respectfully requests that the court accept the bond posted by Mr. Davis and he be released with the conditions of house arrest with high-level electronic monitoring. Now, you know, I said I hate to do this, but I love this shit. I was lying. So remember, the date on this was July 8th, right? So this next document that we are going to look at is called the state's opposition to defendant's motion for reconsideration and reinstatement of the previous bond and counter motion to readdress the bail. Okay. Date of hearing July 23rd, 2024. So they looking to go back to court. This is what they're trying to do. Okay. This is what they're trying to do. Let me come over here and check on my people first, because I ain't finished. I ain't checked on y'all in a You know, I really got to work on that. But in this portion, this is where you are going to hear how Wack be broke. Let's get it. I really hate that my computer is like glitchy right now. I'm ready to start over, honestly. Okay. Because it's screwing me up when it's moving slow. All right. So we got our watermark up. Now, what you are looking at is the surety of bond acceptance, okay? And this is for Keefy D, okay? And you see, you must appear on June 25th of 2024. So this was the surety of bond that went in on the record. We've already gone through that. So as we know, that was the video for the trial that happened. But here is the journal entry from the reporter, okay? This right here, state of Nevada. This is on June 26th. This is from the chambers, all right? And it says, this matter was before the court on June 25th of 2024 for a bond source hearing. After hearing testimony from Cash Jones, who posted the bail, and from Mr. Davis himself, the court took the matter under advisement to review Mr. Jones's provided bank records. The court has determined that Mr. Davis fails to make a prima facie, I don't know if I said that right, showing that the bond was obtained through legal sources. First, the records provided are insufficient to make the requisite showing that the $112,500 bail premium was paid by a legitimate source. The court was provided with 6 months of Bank of America records reflecting the deposits and withdrawals made to Mr. Jones' accounts from December of 2023 to May of 2024. The court notes that these records do not show the actual source of many of the larger deposits to these accounts, only that they were via wire transfer. The wire transfers have names attached, but the court was not provided with any additional documents as to where these wire transfers came from. Pause. Didn't we hear about wire transfers all the way in 2015 from old Wackadoo? Because before we end, I'm going to show you something that was brought to my attention about Mr. Duty Shooter, okay? But we heard about him and these wire transfers and him just putting something in the description and not keeping actual legal ledgers for his business, which though that information is in the transcript, which is the next video that we will get into, and then I will end this off for y'all, and this will be your part one. Means that you are not running legitimate business, okay? But anyway, I digress, and let's progress, all right? The wire transfers have name attached, okay? Additional documents to where the wire. There are at least 2 unexplained counter deposits in the amount of $50,000 each. While there are significant monthly deposits made, there are also substantial withdrawals made from this account. However, in May of 2024, which is the month before the bail premium was paid, the ending balance is insufficient to cover the $112,500 payment. Thus, the courts still do not know how Mr. Jones paid the entire premium. I don't want to keep saying the amount, the entire premium. The court has to couple that uncertainty with Mr. Davis's own statements to his wife. Now, y'all just heard that, and I kind of skipped past that. Let's hear it again. However, in May of 2024, which is the month before the bail premium was paid, the ending balance is insufficient to cover the $112,500 payment. However, in May of 2024, which is the month before the bail premium was paid, the ending balance is insufficient to cover the $112,500 payment. However, in May of 2024, which is the month before the bail premium was paid, the ending balance is insufficient to cover the $112,500 payment. However, in May of 2024, which is the month before the bail premium was paid, the ending balance is insufficient to cover the $112,500 payment. Broke. He didn't even have enough in that account to cover $112,500 payment. He had less than $112,500 in that account. He had underneath that. He did not have enough to make the payment for the bail. But you heard all of that flim flam and moving around of money that ended up happening under mysterious circumstances. But that's because Wack is a shady businessman. And this is why I'm exposing him. This is why Adam needs to watch himself. Now let's get over here to this transcript and let's listen to a little bit of it and what was said up in here. Has nothing to do with the case. So technically he's not doing anything improper by not giving up his records, but he may not have been subpoenaed. We'll find out as we read on. But I wouldn't give up on my records either, because you can get that information from the game stuff. Y'all just trying to be nosy, but I'm here for it because I'm nosy too. Anyway, let's continue. Okay. The courts. Okay. Now this is a portion of the transcripts from the game's court hearing where Wack walked up in there and was not under oath and decided to run his mouth. Mr. Jones, the floor is yours. Again, you do. I'm not forcing. You do. That's what the judge said. Again, you do. I'm not forcing you to say anything. If you would like to address what I just discussed with Mr. Williams, you are certainly entitled to do so. The court reporter, can I get your full name? Cash Jones. And Mr. Williams explained that you reside in LA, but you happen to be in town because your wife has a speaking engagement at the Prudential, and that you learned of this hearing and wanted to come. How coincidental. How coincidental was that? But let me end this for y'all. I wanted to bring that up where the judge is like, you're not obligated to speak. If you do, you do. And basically, if he don't, he don't. Because Wack was never under oath. Old Cash McElroy Jones testified in this court, and he got so comfortable, he began running his mouth a little too much. Now let's get to that part. Wack. I don't work for nobody. I broker dozens of deals for 4, 5 different labels. Live Nation, Nick Masters, the chairman of Live Nation, dozen others. Why? Because in the urban side of music, I can get direct. I can get cheaper prices. So this is all it is. Now I have no contracts with not one of my artists. Not one. Pause. Haven't we been hearing that Blueface is in contract? Didn't they talk about him having a contract? Didn't they say Blueface have a contract? Didn't he sign a 360 deal allegedly? But now you saying you don't have no contracts with not one of your artists. So what did he sign? I digress. Let's keep going because it gets worse. Wait till y'all hear this shit. But what I will do at times with these artists when these artists are in need or something is going on for me to keep my relationship or maybe keep their favor of the artist when I need them to do something or when there is other options for them to do something and I'm one of them options. I will do things. I'm going to read that again. Now, I have no contracts with not one of my artists, not one. But what I will do at times when these artists are in need or something is going on for me to keep my relationship or maybe keep their favor of the artist when I need them to do something or when there is another option for them to do something and I'm one of those options. I will do things. A lot of these artists portray themselves to be one thing and they're not that. Grimy, nasty word. Nasty word. He hems them up and keeps them in his pocket. Y'all just heard that for yourselves. So did Blueface do that show and make him executive producer on it because he needed him to do something to keep the relationship with Ray J? Isn't Blue in need right now? Hasn't Blue been in need? Yeah, he has. And Wack screwed him over. Somebody gonna hate when I say this, but there's a reason that him and Krishan don't get along. I think they see each other. He know he can't pull a fast one on her, and she knows what he all about. Fact. Child, let's continue. Now, what I did tell the attorney was everything that Fifth Amendment has sent Mr. Taylor is in there. Everything. Year 2. I may go out to a label, may say, hey, we need an album. Who can we do an album with, right? And I go out, I talk to 3, 4 different artists and see who's available. Maybe find guys who don't have a deal. And I'll start up broker a deal. Say, hey, if I deliver you 300,000, will you give me 12 songs? They don't get no residuals. They don't get no royalties. They don't get none of that. They say, yeah, then I'll double back and go back to the label and say, okay, well, I need 700,000 to do this album. Now, did you just hear that? He goes to the labels. He says, give me 12 songs. If I deliver you $300,000, will you give me 12 songs? Then he goes to the artist and he finds an artist that don't have a label. Independent artists. Isn't that what we heard the game is? Isn't that what Blueface was? independent artists. He goes to them and he offers them this 12-song album. But they don't get no residuals. And they don't get no royalties, which means they don't make no money off their music. He does. Y'all remember Blueface said there was no money in music? Remember? It's because of this right here. Because of this right here. Because I have to still pay for studio time, producers, clearance fees, everything I have to pay for to. So let me go back to that too. He'll double back to the label and say, give me 700,000. So Wack will take that 700,000 and he'll go pay for everything that needs to be done. And that's how he starts making the album happen. Deliver a free and clear album to the label. Now, what happens is whatever is left in the pot, whether it's 100 grand, 60 grand, whatever is left in the pot after I pay that artist its set fee and I pay all the other little things I have to pay to turn this album in, that's the money Fifth Amendment makes. I'm just a broker for a lot of people. I just signed on Cash Money. I just received a $500,000 wire last week for an artist that I had to send $150,000 to. Correction, $125,000. So that's what I do. My wife is my president of the company. I am CEO of the company. The wife is the president and he is the CEO of the company. Just set your wife up. I see why Kim left. I wouldn't want to be bothered with him neither. Set me up. I'm gonna just throw my wife in the lion's den. Why not? Facts. R&B is next. Thank you. My office hours are between 9 and 5. Fat Dom, I'm Fat Dom. What's the lies? She said Wack is lying. Bingo, De Niro Jones. I like you because you be on it. Him. Yeah, her. I mean, you could say that again. They all going down. Okay, so now let's continue. Okay, so when it comes to Mr. Taylor, I've known Mr. Taylor for a very, very long time. This hard money thing, it got done based upon my relationship. It was a hard money loan. As you know, it's not conventional. Somebody I knew, investors, they want to put their money up. They didn't trust Mr. Taylor. But the 10-year relationship I had with the guy, he did it based upon my handshake. But my handshake is saying, hey, look, anytime things go bad, I will fill in the blanks to maintain my relationship. He breached it. They foreclosed on him as we speak. He breached that. Is this man admitting to illegal activity? I swear to God, this sounds like a hood gangster, like a Tubi gangster movie. So it was a third on the home for like 70 grand. That was due, right? Came January, February, whatever it was due. I get the call. Hey, this is not in. This, that. Guy's not responding, such and such. I call the guy, hey, they need 70 grand. Man, I don't have it. I don't know how. I don't know what to do, right? I call my friend back. I tell you what, I'll get you 70 grand. I send it to you on my end. House is good. House is good. I tell Mr. Taylor, hey, listen, something is going to come up. I don't know where. Somebody may call me for a show or whatever it may be. Or I may say I need 30 grand. and he's gonna go on that stage and dance, and I'm gonna make 30 of my 70 back. That's what I do. Now, this was Wack's words in court, not under oath, to a judge. Now, I know a lot of people will sit up here and they'll try to clear it up and say, Wack was just trying to show that the game didn't have no money. But the game don't have no money like that. The game has to work for Wack to get out of debt from Wack. See, once you get in bed with Wack, ain't no getting out. He lays the trap to keep you indebted to him. And if going through all of these cases thus far has not shown you that, then I don't know what else will. Think about the preacher was in need. He was in need. And Wack showed up as a friend in need, like to a friend in need, and offered him something for something in return. Quid pro quo. You do this, I'll give you this. I give you this, you do this. That's how it works. He fell through the game, that is. He needed 70 grand. Wack figured out a way to get the 70 grand and paid it. But told us that when it's time, when he's in need, he gonna pull the game out and make him tap dance for him so he can get his fee. Child. Listen, I'm gonna put the links to all of these videos in the description box. Go watch these videos, but we're gonna be back with a part 2. And we're gonna break down all of the underhanded business that goes on with Wack, and we're gonna put that out next Saturday. Okay? So I know it's midnight, and y'all finna get this after midnight on the East Coast. If you over on the West Coast, it's 9 p.m. If you are overseas, it's about 5, 6 in the morning over there. So y'all probably get this when y'all wake up. But y'all can expect the part 2 on Saturday. And we will go into part 2 of Rock Nation next week. So y'all, don't forget to like this video, subscribe if you're new to the channel, and let me know what you think down in the comment section below. And I will see y'all in the next video. Peace, y'all.